Hi. Okay, I am so sorry I'm late. I hate being late, but there were circumstances beyond my control. So here, let me pull up this independent contractor agreement that we're going to walk through. And give me one quick second. I'm going to share this video in the group. Where are you? Hi, there you are. Okay. It's strange. It's not showing. And give me one quick second. Oh, there it is. So let me share it in the group. All right. Okay, sorry I'm late. I really hate being, what am I, 7 minutes late? But again, there were circumstances beyond my control. So I'm here now. And so today I wanted to walk through an independent contractor agreement. Actually, first let me say a couple, or take care of a couple of housekeeping things. So we reached 1,000 members. It's really cool. I never thought that my group would ever grow that big. You know, it's kind of like, I guess, when you're young and you, like, you're 5 or whatever, and you think you can't imagine what life is beyond like 18 years old or something like that. I feel like I've kind of reached that 18-year-old mark. I never thought I would actually get past it. So it's really cool. Thank you guys for joining. And as I've mentioned before, go ahead, and if you have a general question, go ahead and post it in the group. There's files. So if you go to the file section of the group, you'll see different templates that I've kind of walked through before. I made comments on it. They're in red. So if you decide to use the templates for your business, that's totally okay. I don't have a problem with that. You just can't sell it or use it for monetary gain. And you can't post it anywhere else. So if you want to use it internally, that's perfectly okay with me. But beware. So you might need to change it around or customize it or whatever, however you see fit. And then also, if you go into the photos section, there's a couple of infographics that I created a few months back, and you'll be able to see, actually the one I'm going to reference today is an employee versus independent contractor, kind of some of the factors that the Department of Labor and the IRS use to make the distinction. And I don't actually specify DOL versus the IRS, but I kind of all merge them together. So anyway, you'll see a couple of helpful files there too. And I know there's probably about 15, maybe 15, 20 lawyers in the group, and that's great. So y'all can feel free to jump in and answer some questions if you want to. I'm probably going to focus in the next couple of weeks on talking about terms and conditions, website things, and maybe some issues pertaining to retailers, because the Christmas season is coming up, and I know it's going to start jumping off pretty quickly here for a lot of e-commerce business. So I want to make sure that I'm helpful, and I'm going to focus on that. So if you're a lawyer and you have a topic that you want to talk on, or topic that you want to post about, go ahead and message me. I'm really open to that. I run it pretty much myself. I try to post as much helpful information as I can, but I'm one person and I actually have to like work for clients. So I can't always post when I want to. So if you guys want to jump in, that's great. Go ahead and message me. And I know a lot of folks are kind of like, well, I don't know if I should post this or not post this. Like if you have a reference for a group or something like that, I don't have a problem with anyone posting valuable information. The rule of thumb that I go by is that if it's something that someone would pay me for, then I post that. I want it to be highly valuable. Anything that I put in this group, I want it to be highly valuable. Or if I see like a post about an article that's, legally relevant to a small business, then I'll go ahead and post that too. But I want to make sure that if somebody is going to post something, it needs to be highly valuable. Please don't post anything referencing Legal Shield or just, hey, here I sell some services. Don't do that, because it will get deleted. And if it happens a lot, then I'll just remove you from the group. Fortunately, I have not had to remove anybody from the group, so that's cool. Again, I want to make sure this group stays super, super valuable. And for the new members that join, I see you guys are posting, thanks for, letting me in or whatever. And that's cool. I like that. I always try to respond as much as I can. So I'll probably let those posts stay for maybe a day or so, and then I'll take them down. I don't want to clutter anybody's newsfeed. Again, I want to make sure that anything that's posted in this group is highly relevant and it's highly valuable. And so if folks see a lot of posts like that, whereas I love it and it makes me feel so happy and so good, I just don't want other people to start deleting, or not deleting, but I don't want people to start unfollowing the group because they're getting too many things like that in their feed. So quality over quantity is my motto that I'm using for my group. So, okay. So let's get going. So what I'm doing with this independent contractor agreement, what I did before with the non-disclosure, my goal is to basically document kind of how or my thought process as I go through these documents. Independent contractor agreements and non-disclosure agreements are by far the most common agreements that I review, because I work mainly with small businesses, and small businesses are not trying to hire employees until it's absolutely necessary, and because it's expensive because you have to pay payroll taxes and things like that. I don't have to explain it to you all because you all know. Most of you already have your business. So this agreement is very common. So a lot of times businesses cut corners. I don't want to say cut corners, but they try to save costs. And what happens is you go to like Rocket Lawyer or LegalZoom and you download these templates and you start using them. And like I've said before in the previous posts, is templates untouched are okay. It's kind of like fast food. It gets you by, but it's not something you want to continue to do. Once you're beyond a point where you can afford something more robust and something that's going to be customized and something that's going to fit your business a lot better, that's what you really need to start using. And one more thing. Sorry, let me back up. Why is that popping up? Sorry, let me close this. So if you're on my page and you post a comment, I'm going to have my phone right here. I'm going to try to check it every once in a while. I'll be able to see your comment. But if you're looking at this video through the group, if you post a comment on that link, I'm not going to be able to see it. I'll probably circle back around once this video is done, and then I'll type answers to it. So if I'm going to try to kind of push through this, and if I see something or if I remember to check, I'll try to answer your question. But I want to keep going and, finish this whole review first. And then, like I said, after, when I get offline, then I'll go back and take a look at the questions and things like that and answer it. So, okay, so back to what I was saying about these templates. Even if you have a lawyer who generates a contract for you, a lot of times lawyers, even themselves, they pull these templates from, software that we pay a subscription for every month. And if your lawyer isn't comfortable with writing contracts, then a lot of times they'll just use kind of what's in that template themselves, slap your name in it, put your business's name in it, and just keep it moving. And it's still not very, robust. So I want to show you and kind of walk you through a lot of the weaknesses of a template. 9 times out of 10, it's not going to be a problem for you. Your deal will go through and it'll be fine and it'll be great and dandy. But it's going to be, that 10% or that 5%, and it's going to be bad. When it hits, it's going to be bad. So I want you to make an informed decision, and you should understand kind of what your risks are when you use templates like that. So that's what I'm going to do. All right, let's get going on this. I've talked way too much about that stuff. So I'm going to read it through. I'm going to highlight it. I'm not going to actually type in any comments. I'm going to do that after the video is over, and then I'll post this document with my comments and my highlights into the group so you can see, everything that I said, or it'll be documented, everything that I said, everything that I went through. All right, so here we go. Independent Contractor Agreement. This agreement, when accepted by blank, a blank entity of owner, okay, located at, put your address, company is made as of blank, so the date goes there, by and between the company and blank, a blank entity of business partner located. Okay, so I'm kind of going through this the first time because I want to make sure it's like fresh, like as I'm thinking through it. So this is kind of the first time I've taken a look at this template. So entity of business partner. That right there makes me uncomfortable. Business partner, let me highlight that right there for us. Even though it's in these brackets right here, what it's signaling you to do is to remove this wording. Most people, when they get templates like this, you may forget to do that. And the reason why I have a problem with this is business partner. Partner has a very specific meaning legally. You don't want a contractor, an independent contractor, to ever be perceived as your partner. So this wording right here, as long as you remember to remove it, you're fine and it's not going to be a problem. But if you forget to remove that, that could be really, really, really bad. So I have a problem with that wording right there. Located at blank, okay, address, and then contractor. In consideration of their mutual promises made herein and for other good and valuable consideration, the parties hereby agree as follows. Gotcha. Scope of work. The company engages the contractor to furnish the work described in the schedule attached to this agreement. Okay, so schedule. So you got to make sure whenever it says attachments, you have to make sure that you go back and make sure that there is an attachment. And incorporated herein by reference as exhibit, blah, blah, blah. Okay, so just highlight that. Make sure you go back and circle back and actually have an attachment and make sure it's labeled correctly and it's consistent with this wording right here. At the time specified in that schedule. And the contractor agrees. Okay, so there needs to be a timeline in that schedule too. So time specified, I'm just going to highlight that. And the contractor agrees to furnish the work at the time specified in the schedule. The attached schedule may be modified from time to time upon agreement of the parties. Okay, time to time upon agreement. I don't really like that because from time to time, that's fine, but upon agreement, there's no specification that it needs to be in writing. So what happens is a lot of folks don't know you can have oral contracts and they can be binding. The hard part about oral contracts is that they're harder to prove, but now because there's recording devices, everybody has their phone on them and everybody's recording something at any given moment, it's a lot easier to prove now. So you want to make sure that every agreement or every change is going to be in writing. So it's really important that no oral modifications are going to be valid. When you're working with contractors, you're conversing a whole lot, so it's going to be easy to agree to something different verbally. Things get lost in translation, so make sure it's always in writing. All right, I've beat that dead horse enough. If the company requests modified or additional services, the contractor shall provide the company with an estimate of changes to the compensation payable and the impact upon the schedule for completion of the services, if any. Okay, that's good. So you always want to make sure you get any changes or get the monetary value of any changes in writing. The contractor shall proceed with such modified or additional services only upon receipt of written approval by the company. Okay, that's good. All right, so it sounds like written approval by the company. This is going to be written in favor of the company. That right there kind of signals that for me. It's not a problem per se. It's just if you are the individual, if you're the independent contractor, then this may not be the right agreement that you'd want to start with. I mean, you can always change it to make it more favorable to you, but it may be more of a hassle. You might want to start with something that's a little bit more in your favor. However, if you're the company, then this is probably a good agreement to start with. So. Price and payment. The company agrees to pay the contractor in accordance with the price and payment terms set forth in the schedule attached to this agreement, and the contractor agrees to accept such amounts as full payment for its work and to sign such waivers of lien, affidavits, and receipts as the company shall request in order to acknowledge the payment. The contractor acknowledges that its federal employer tax identification number or social security number in the case of an individual is correctly set forth in the schedule attached to this agreement. Okay, so social security number, you never want to use your social security number, so never. Even if you're an individual and you have not created an actual separate entity, you still need to have a tax ID number, otherwise known as an employer ID number. Never, ever, ever use your social security number. Can't say that enough. Okay. Price and payment. Okay, so I don't have any real issues with the price and the payment. Oh, let's see. Independent contractor relationship. Okay, this section I can tell is going to be really important. And I'll tell you why. Let me read it and then I'll tell you why in a minute. The contractor is an independent contractor and is not an employee, servant, agent, partner, or joint venture of the company. Okay, so that partner, see, it's saying that you're not a partner, and that's kind of speaks to what I was saying before about why that partner language should not make its way anywhere in that that top part. The company shall determine the work to be done by the contractor, but the contractor shall determine the legal means by which the contractor accomplishes the work specified by the company. The company is not responsible for withholding and shall not withhold FICA or taxes of any kind from any payments it owes the contractor. Neither the contractor nor its employees shall be entitled to receive any benefits which employees of the company are entitled to receive, and shall not be entitled to workers' compensation, unemployment compensation, medical insurance, life insurance, paid vacations, paid holidays, pension, profit sharing, or Social Security on account of their work for the company. Okay, that wording right there is actually pretty good. So why this section is important is kind of, I touched on it when I first started talking, is you don't want an independent contractor to ever be perceived as being your company's employee. And the reason being is because if you've been paying an independent contractor as such, and then say the Department of Labor comes in and audits you and says, no, actually that independent contractor is really an employee, it's going to really suck for you, because not only are you going to be hit with fines and interest and penalties and all like that and things like that, but you're going to be forced to pay back payroll taxes and whatever from the very beginning of what the Department of Labor would consider their employment. So it's going to be really, really bad. So this section right here, what it does is it essentially says in writing, hey, you are independent, right? And you're not going to be you're not our employee. And it's very important to write that in the contract, because the first thing the Department of Labor, if you ever get audited, is going to do is they're going to look for this contract, this document, and it's going to look for this wording. And it's a very essential part to have this wording there. Also, but you still need to actually be doing all of these things. You need to have, I'm pointing like you guys can see, my fingers pointing to the screen. It needs to be specified in the contract, but also you need to make sure that the contractor is adhering to everything that's going to be in this section right here. It's kind of like, like if you love somebody, say like in a relationship, if you love somebody, and it's always important to say, hey, I love you. It's important that they hear it, but then also it's important that you do things that shows love. So it's like two very important pieces of the relationship. So this in writing, it needs to say that. One thing that I would say the section needs to have, or it would help if it had, is things that talk about the independence of the contractor. Like, say, some of the items that the Department of Labor looks at is whether or not the independent contractor has a website, whether or not they're going after additional clients, additional business. If an independent contractor is using a company as its sole client, that's not going to look good. It sounds more like an employee. If the independent contractor doesn't have a website, meaning they don't look like they have a legitimate business and they're legitimately pursuing other clients for their business, that's not going to look good. It's going to look like more of an employee. So I would personally, put some things in there that talks a little bit about that, like saying company understands that contractor will pursue other clients or something like that, and touch a little bit more on the Department of Labor and the IRS factors. So again, if you go to the file section, you can probably do it now. Go to the file section, not the files, go to the photos in the group, and you'll be able to pull up, there's 3 infographics about the factors that the Department of Labor and the IRS use when distinguishing independent contractor, I cannot talk, an independent contractor from an employee. So some of those factors, as many factors from those infographics as I personally, if I was looking at this for my client, as I could fit in this paragraph, like I would do that. So I would maybe, I'd add maybe another paragraph. Okay. Business of contractor. The contractor represents and warrants to the company that the contractor is engaged in an independent calling and has complied with all local, state, and federal laws regarding business permits and licenses that may be required to carry out the independent calling and to perform the services specified in this agreement. Upon request by the company, the contractor shall provide the company with copies of all documents reasonably requested by the company to verify the contractor's established business. And the representations set forth herein. Okay, so this is kind of like a continuation of that, this section up here. Actually, I personally would merge the two. I think they both talk to the same thing. I think it's a little sloppy to have it separated, but it's okay because this agreement isn't very long, so it's okay if it's two separate sections. So the reason why I highlighted this, verify the contractor's established business and the representation set forth herein, is that if the company is the person who's, if I'm looking at this on behalf of the company, what I would say is it's very important, if the company is going to include this wording, that they actually verify the contractor's established business. Because if you don't, that could be grounds for negligence if the contractor then somehow screws something up or didn't perform to a certain level of competence or something like that. So the company is going to be obligated to make sure the contractor is a legitimate business, and this wording right here, because it's included, might be evidence of, like I said, gross negligence or or just negligence when hiring the contractor if they don't do it. So just make sure that you are actually doing your due diligence as a company when you hire an independent contractor. Notwithstanding any due diligence performed by the company with respect to the subject matter of these representations, the contractor shall indemnify, and hold the company, its directors and officers, and its agents and employees harmless from any and all claims, causes of action, losses, damage, liabilities, costs, and expenses, including attorney's fees arising from breach of the representation set forth in this section. Okay, that's just saying that independent contractor, if you lied to us about your experience or anything pertaining to your ability to perform the job, then we're going to come after you if anybody comes after us. And I don't really have a huge problem with this section right here. Indemnification clauses are kind of onerous, but I think indemnification clauses are okay as long as the party, as long as it rests on the party who has control over that particular thing. So if the independent contractor is the one performing the work and they're actually are very, completely independent, then the risk should rest with them because they're the ones performing the work. The company has very little control over them. So that's why this clause is there. And I totally can understand it being there. So I don't have a problem with it. Employees of contractor. The contractor shall be solely responsible for paying its employees. The contractor shall be solely responsible for paying any and all taxes, FICA, workers' compensation. Okay, this is just redundant. I'd probably take that out or merge it with the section above. I can't remember what it was, but yeah. I mean, it's fine if it's in there. It's just kind of sloppy. Paid vacations, paid holidays, pension, profit sharing, and other benefits for the contractor and employees, servants, and agents. Okay, that's fine. I was talking with somebody last night about taxes. Please make sure that you're not removing any taxes for your independent contractor. They literally should be a standalone business. So you wouldn't remove taxes for, any other business. You'd pay them whatever amount is owed, and it's their responsibility to pay the taxes. So it's very, very, very important that don't take out any taxes, because that seems and sounds and feels like an employee, and that's what you don't want. That's what you don't want to do. Okay. Insurance. The contractor shall furnish the company with current certificates of coverage of the contractor and proof of payment by the contractor for workers' compensation insurance, general liability insurance, motor vehicle insurance, and such other insurance as the company may require from time to time. The contractor shall maintain all insurance coverage and shall furnish the company with certificates of renewal coverage and proofs of premium payments. If the contractor fails to pay a premium for insurance required by this paragraph before it becomes due, the company may pay the premium and deduct the amount paid from any payments due the contractor and recover the balance from the contractor directly. Okay, this is okay. It needs work though, because current certificates of coverage, proof of payment, I would say if I was the company, there needs to be insurance amounts. It needs to specify how much you're insured for. Usually it's like $1 million or something like that. And I think it needs to be specified a little bit. It's not a huge problem, but I mean, what's the point of requiring an independent contractor to take out insurance and they only take out like a $20,000 policy, you know? So that's just pointless. So you want to make sure that the amounts that they take out for insurance are going to be sufficient to cover any sort of liability, and usually that's going to be in the millions. I mean, usually, you know, cases don't settle for anything less than like millions of dollars these days, it feels like, especially if it's between an individual and a company. So let's see, contractor shall maintain all insurance coverage and shall furnish the company with certificates. And also one other thing I'd say is that if you're the company, you might want to put in their requirement to have your company named as an additional insured, so that way it gives you privity of contract between the insurance company, so you can make a claim directly. It usually doesn't cost the independent, you know, contractor any additional money, but if I was doing this on behalf of the company, I'd want to see that in there too. Let's see. Yeah, I mean, everything else is probably, it's okay. Risk. The contractor shall perform the work at its own risk. Okay, that's important because, again, you want to make sure that the risk is borne by the independent contractor, because it lends itself to the contractor being an actual business, a standalone business. So keep that in there. The contractor assumes all responsibility for the conditions of tools, equipment, material, and job site. Okay, again, talks to the independence of the contractor. The company will not reimburse the contractor for any expenses incurred by contractor as a result of services rendered under this agreement, including but not limited to car-related expenses, telephone expenses, and blank. Yeah, okay, you can add whatever you want in there. That's fine. Indemnity and warranty. It's kind of weird because we just saw a clause on indemnification, but all right. The contractor shall at all times comply with all applicable laws, statutes, ordinances, rules, regulations, and other governmental requirements. The contractor shall indemnify and hold the company, its directors and officers, and its agents and employees harmless from any and all claims, causes of action, losses, damage, liabilities, costs, and expenses, including attorney's fees arising from the death or injury to any person, from damage to or destruction of property, or from breach of the warranties in this section arising from the provision of services by contractor, its agents, or employees. Again, yeah, I don't have a huge problem with that. In the case where the contractor does have to take very specific instructions from the company, I might have a problem with that if I'm, you know, representing the contractor. I'd say, well, no, if you're controlling more of my day-to-day kind of, or not day-to-day, because you don't want day-to-day, but if you're controlling more of my actions for, say, a particular project, and you're following the instructions that are given to you by the company, then I might have a problem with that right there, on behalf of the contractor. Because again, remember, the risk should reside with the party that has the most control. So if the company is more in control of what's taking place, the risk should reside there. However, if the contractor is in control of, what's happening in the performance, then the contractor should have that risk. So right now it's okay the way it is, because obviously I'm not arguing on behalf of the company or the contractor, but just keep that in mind if you are, depending on which side you're on. So assignment, the company may assign any or all of its rights and duties under this agreement at any time and from time to time without the consent of the contractor. Okay, I mean, I understand that, say you sell your company and, the new owner takes over this agreement, and that's what that is. That's what that means, may assign any or all of its rights and duties. Or say they want to take out a loan based on something, a receivable, maybe they want to throw this in there. I mean, I'm just kind of throwing that out there. I can't really imagine that ever happening, but who knows? They might need this contract as collateral of some sort. Then that's okay. However, I still feel like it needs to have some notification verbiage in there somewhere. From time to time without the consent of the contractor. Okay, I can understand consent not being necessary, but it's still, notification would be helpful. So I'll just highlight that just to go back and make a note. The contractor may not assign any of its rights or duties under this assignment. It should be agreement. Under this agreement without, sorry, my dad. Did I not turn my notifications off? I thought I did. Okay. The contractor may not assign any of its rights or duties under this agreement without the prior written consent of the company. This right here might be problematic, and I'll tell you why. Because, again, not to belabor the point, but the independent contractor should look and feel like an individual business. So the company should not have a lot of control over the contractor. The contractor should be able to hire subcontractors as needed, especially if they're an expert in their field and they, have certain individuals that they've used in the past to assist with a certain job. Then they should be able to hire, as needed without the consent or even really notification of the company. So that right there, it just weakens the position of the independent contractor being independent. It's not the end all be all. However, just keep that in mind. So just keep it in mind, so you can make an informed decision. Term and termination. Hold on, let me just check one thing right quick, make sure everything is still going. Sorry, give me one quick sec. Okay, well, it's still going. All right, so the term and termination, time is of the essence. Okay, this is important. Time is of the essence because it means that if you as an independent contractor are late with anything, then you're going to be in breach of the contract. So if you have any sort of time constraints, make sure that you're on time delivering, because if you don't, you're going to be in breach, and it's going to suck, because I'm guessing there might be provisions farther down that say if you're in breach, then the company can come after you and sue you. So that's no bueno. And the provision of services under this agreement is effective as of the date signed by both parties and shall terminate upon contractor's completion of the services in accordance with the schedule attached to this agreement, unless terminated in accordance with the provisions set forth in this section. Okay, I don't know how to turn those notifications off. Notwithstanding anything herein to the contrary, the company reserves the right to terminate this agreement at any time upon delivery of written notice of termination. Yeah, I don't like that. And contractor shall be compensated for all services provided prior to such termination. Ooh, I hate that. I hate that. I hate it. Oh gosh, and I'll tell you why I hate that right there is because anybody who's an independent contractor knows that there are a lot of upfront costs that you don't recover unless you perform the entire agreement. So that right there, giving the company the ability to terminate you, it just makes me really uncomfortable because the independent contractor is going to end up getting screwed. So there's a couple of ways around something like this. Number one, make sure you have a kill fee kind of built into your schedule, a kill fee. So that way, if you perform services that do require a lot of upfront costs or a lot of time upfront, then you're going to be compensated for that. So that's the first thing. And then the second thing is if you don't have a kill fee, then maybe have some sort of schedule where you have milestones and make sure it's very, very clear. Because if it's just a flat fee, if it's just a big chunk, then it's going to be really difficult to recover all of your costs because the company may say, well, I didn't engage you to the end of it, so I don't owe you that fee at all. And then you got to fight for it. So I don't really like that right there. The company being able to terminate, whenever they want to, that's just not really fair in my opinion. I don't really like it, but the company may terminate this agreement immediately. However, should contractor fail to perform any of its obligations hereunder, including without limitation completion of the services provided for herein in a timely manner. Okay, so that makes me a little uncomfortable, but I mean, it's not horrible. Again, I still think it's fair to have some sort of wording that gives maybe a 30-day notice. Terminating immediately, I don't really like that. And I think it should always be for cause. The contractor acknowledges and agrees that its obligations pursuant to Section Q code. I don't know what that is. That's a typo, I guess. As well as any obligation to protect confidential information or trade secrets of the company and assign intellectual property rights to the company shall survive the termination or expiration of this agreement. Okay, it's just saying that it's going to survive. Okay, so sorry, I stopped because I don't remember reading confidential. Oh, it's down here. Okay. All right, I'll get to that in a minute. Okay, that's fine. Entire agreement. This agreement represents the entire agreement of the parties hereto relating to the subject matter hereof, and any prior agreements, promises, negotiations, or representations, whether oral or written, not expressly set forth in this agreement, are of no force and effect. This agreement may be modified only by a writing signed by both parties. Okay, that's just saying that if you have any verbal agreements that are contrary to what's written in this contract right here, then those verbal agreements are null and void, and only what's written in the four corners of this document is going to be enforceable. So that's common. You just want to make sure that if anything is inconsistent, that you bring that up before you sign this document right here. Governing law. This agreement shall be governed and construed in accordance with the laws of the state of blank. Okay, this section right here needs to be elaborated. I mentioned it in the other live with the confidentiality agreement. So this is okay, but you also want to limit any suits that are brought against you to be brought in the county, city, and state, obviously, where your company is located, because it's really inconvenient and annoying and expensive to have to defend a suit that's in a completely different state. So you want to make sure that you limit the ability for anybody to sue you. It has to be brought, in your county and in your state. So that could be elaborated a bit more. Confidentiality. Okay, I can tell you right now, this confidentiality section sucks. It's way too short. It's teeny tiny. Confidentiality should be like a page in and of itself, at least a page. I literally yesterday just finished reviewing a confidentiality agreement, and it was, I want to say 3 pages, and it was a pretty good document. but it was 3 pages. So, I've said it before, with the law, the devil's in the details. If this is way too general, contractor acknowledges and agrees all intellectual property and any other plan specific. Yeah. See, I've read that many times before. I've read paragraphs like that. This is way too general. I just highlight this whole thing and be like, this is completely, totally, 100% insufficient. Hate that section. Ownership of intellectual property. Contractor agrees that all copyrightable material, including writing, software, drawings, and designs, and all ideas of engineering. Okay. All copyrightable material. It should say like copyrightable, trademarkable, and patentable. Copyrights, trademarks, and patents are 3 very different separate things. So it kind of groups everything. It looks like, yeah, it groups everything under copyright. That's bad. To me, that shows incompetence, whoever created this template. It wasn't me, thankfully. So I have a problem with that. And a design might fall under a trademark. So that sounds like it's more trademark. Inventions is definitely more like falls under patents. So I would add trademarks and patents to this right here. Conceived or reduced to practice by the contractor, whether individually or in collaboration with others during the course of performance under this agreement, which relate in any manner to the company's business or to the services provided hereunder, are the sole property of the company. Okay. And the contractor hereby assigns to the company all right, title, and interest into all such intellectual property, including without limitation any worldwide copyrights, moral rights, patents, and any and all other such rights of whatever kind to obtain registrations, renewals, reissues, and extensions of the same. The contractor agrees to execute such further documents and to do such further acts as may be necessary to perfect the foregoing assignment and to protect the company's rights. The contractor shall obtain from each employee or third-party contractor of the contractor who makes or has made any contribution to the services hereunder a written agreement in form. Sorry, you hear my cat crying. In a form satisfactory to the company, assigning to the contractor all rights in or to any work performed by such party in the course of performing the services hereunder. Man, this is a long section. And any and all results and proceeds thereof throughout the world, including without limitation all copyright rights therein and all renewals and extensions thereof. Again, they leave out trademarks and patents. The contractor promptly will furnish the company with copies of all such agreements secured by the contractor pursuant to this section. Okay. Yeah. I think that section is probably okay. I just would say, if I'm reading this on behalf of the independent contractor, make sure that you do include this assignment language in any subcontractor agreements that you issue or other independent contractor agreements that you issue to other individuals. So that way you do in fact own the rights to, any of the works that are created, and then it is subsequently transferred to the company here. So that's totally okay. I don't have a problem with that. Witness hero, the parties have executed, blah, 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 blah. Okay, yeah, that's fine. I don't have a huge problem with that section. Let me get I have, like I said before, keep like a written note on other generally included sections and contracts, and I already mentioned a schedule. So be sure to include the schedule in there. And let's see, what else can I think of? The indemnification. I'd like to see maybe a little bit more language about a mutual indemnification. I think I touched on it a little bit earlier. I think mutual is more fair, and a more fair contract that goes both ways and is more balanced is a stronger contract. I've mentioned that to other clients. Don't always try to use all of your leverage and, create a contract that's going to have your foot on, the other party's neck, proverbial neck. You want to try to make it as balanced as possible, because that is going to be a stronger contract. Let's see. What else can I think of? You know, there's nothing in there. Actually, I just thought of this. There's nothing in there that keeps independent contractors from poaching employees of the company, and then vice versa. That's a really big one. Especially if the independent contractor has a staff, then companies might be tempted to take some of those employees away. So definitely put some verbiage in there for that. I didn't see anything in there for that. That's a huge one. Let's see. What else? Yeah, there wasn't anything in there about severability. So a severability clause it says basically if there's any term in there that's going to be considered invalid or unenforceable, that the rest of the contract still stands as long as the ultimate essence of the contract remains intact. There was nothing in there that talked to that, so I would say that probably needs to be in there as well. So overall, this isn't a horrible template, but they never are really horrible. I mean, you can see, hopefully, from me walking through it, there's quite a few holes. There's maybe 2 major issues that I had with it, that if I were rewriting it, I would change for sure. But, again, it just kind of depends on what party you are, which side of the equation you're on. Hopefully, that helps. And again, I'm going to make my comments in here, and then I'm going to post it into the group, and you can kind of go through my comments if you missed the live, or not. So let me see if I had any questions. Nope, I don't see any questions. Yay. All right, so if you guys have any questions, please, 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 you can post them in the group. You can message me. I see all of my messages, or you can email me. My email address is raven.willis@govcontractsupport.com. That's govcontractsupport.com. You can email me. And let's see, how else can you get in touch with me? But actually, Messenger is probably the best way to get in touch with me because I see those notifications pretty quickly. So, all right. Thank you guys. I hope this wasn't too long. I hope it was helpful. So please let me know if it was helpful. Again, I'm going to start focusing a little bit more on retail terms and conditions, maybe some websites. So I'm going to step away from doing a live from an agreement like this here. I'm pointing like you can see what I'm pointing to on my computer screen. I'll circle it like that. So I'm going to step away from this and maybe focus on, like I said, e-commerce. If you guys have a website, or if you know of a website, maybe not your website, but if you know of a website that would be good for me to walk through, that would be awesome. Let me know. I'll walk through it and just kind of snoop around, dig around, and see and make an example of things like not to do, or I don't know, maybe product descriptions and terms and conditions. I'll go and take a look at that and just kind of do it and walk through it out loud and talk through what I see, maybe some risks or legal issues that they may have in the future. I don't know. So let me know if anybody's up for that. But okay, I'm done. Thank you guys so much for joining me. I really appreciate it. Again, let me know if it's helpful and if you want to see more. And if you do want to see more, like some agreements that you want me to walk through. I love ripping these contracts to shred. It's my life. And then I write them and build them back up again. That's what I do. So, all right. You guys take care and you guys have a blessed day.